Welcome to Columbia. Our commencement ceremony was 2 days ago, so if you walked through the main campus on the way from the subway, you saw them dismantling the bleachers. This is the biennial EPA Region 2 conference. This event started in 1994, and we've had it every 2 years since then, though we skipped 2020 because of the pandemic. So today is the 15th of these conferences. We held it in 2021 on Zoom, and we're happy to be back in person today. My name is Michael Gerrard. I teach environmental law and energy law here at Columbia Law School, and I founded and direct the Sabin Center for Climate Change Law. It's my honor to chair this conference. The conference is co-sponsored by EPA Region 2, the American Bar Association Section of Environment, Energy, and Resources, the New York State Bar Association Environmental and Energy Law Section, the New Jersey Bar Association's Environmental Law Section, the New York City Bar Association Environmental Law Committee, the Sabin Center for Climate Change Law, and the Columbia Climate School. I'd like to thank the other members of the Planning Committee who helped put this together. Paul Simon for EPA Region 2, Martin Baker for the New York State Bar, Margaret Berry for the New York City Bar, Monica Schreck for the New Jersey Bar, and John Galacci for ABA. I also want to thank my assistant, Kemi Adateo, who handled many of the logistics, Pamela Ascano, who handled the CLE, Shar Smulian for the catering, John Van Brownsburg for the AV, and several volunteers who are helping us with registration. So our objective today is for all of us to learn more about the recent and upcoming plans of US EPA and of the state environmental agencies. We're privileged to have with us today top officials from Region 2 and from the state environmental agencies, including Puerto Rico, and from the Army Corps of Engineers. Before we get started, a few administrative matters. In order to get New York or New Jersey CLE credit, you need to sign in, and then before you leave, sign out. Please be sure to remember to sign out on your way out, and the sheets are going to be on the table outside. Please remember that. CLE certificates will be sent to the email address that you used to register. If you want New Jersey CLE, when you get the certificate in the email, it'll also tell you where to send it for a reciprocal New Jersey credit. We also ask everyone to fill out an evaluation form, which is very helpful to us in planning future programs. Even if you're not here for CLE credit, please fill out the evaluation form and put it in the box marked evaluation forms outside. We are video recording the program. The video will be posted on the Sabin Center's website. Yesterday, we emailed to everyone who had pre-registered the bios of all the speakers and the CLE materials and some other items. They're also available if you scan the QR codes that you'll see outside. If you're in my generation and you don't really understand QR codes, ask someone younger. Speaking of technology, this would be a good time to turn off your phones, but there is Wi-Fi, and the network is cleverly called Columbia University. No code is necessary for you to get onto it. So we have a great deal to cover today, and since the bios are all available by the email we sent out and via the QR code, we won't spend a lot of time going through them. Each moderator will introduce each speaker before they speak, and then we'll take questions after all the speakers on a given panel have talked. The restrooms are outside to the left. So that's it for the logistics, and let's go straight to the first panel. It's about climate change and air pollution, which are obviously among the most pressing environmental issues these days. We are all aware that during the prior administration, EPA was forced to weaken and in some cases abandon many of its programs on climate change and to weaken its air pollution efforts. During that time, several states, notably including New York and New Jersey, stepped up to take their own actions. And under the new administration, we're seeing quite a bit of activity restoring and moving beyond the prior regulations. And so we're about to hear from EPA and the states about what they've been up to. Our first speaker is Joseph Siegel, who's been an attorney in EPA Region 2 Air Branch for nearly 37 years. Joe also teaches climate adaptation and the law at the Haub School of Law at Pace University and environmental dispute resolution at Hofstra. He's going to talk about EPA's work on climate change. And after Joe, we're going to hear from his colleague Liliana Villatora, who's going to talk about EPA's work on air pollution matters other than climate change. So, Joe.
Thanks, Mike. Thank you for having me here, and it's great to be with all of you in person after such a long period of time. I'll be talking about EPA's climate change. Oh, did I hit the wrong button? Oh, okay, this one, maybe this one. Okay, I'll be talking about EPA's efforts on climate change, and in particular, I'll be focusing on the Inflation Reduction Act, how we're implementing that, the greenhouse gas regulatory developments, as well as some adaptation planning. Okay, so I'll start with the Inflation Reduction Act, or the IRA, which makes historic investments in climate action that are expected to reduce U.S. greenhouse gas emissions by about 40% below 2005 levels by 2030, which gets us a long way toward the United States target under the Paris Agreement. EPA is going to play a major role in delivering these programs. There's $41.5 billion appropriated for EPA, and there's also another $11.7 billion related to the Superfund tax, which I won't be talking about today. And by the way, I'll be speeding through a lot of these slides, but you can take a closer look later on when they're posted. Okay, so first a breakdown. Most of the money on the IRA is in the form of tax credits, $271 billion. But after that, there are several agencies that are receiving a big chunk of that, and EPA is at the top. And I'll be focusing on the $41.5 billion that EPA is receiving. And in particular, there are 6 new programs that cover most of the money that EPA will be receiving. I'll be focusing on the first 2 you see there, the Greenhouse Gas Reduction Fund at $27 billion and the Climate Pollution Reduction Grant Program at $5 billion. The IRA amends the Clean Air Act to incorporate each of these 6 programs. First, I'll go into the Greenhouse Gas Reduction Fund. That's the $27 billion fund. And the IRA created this program under Section 134 of the Clean Air Act. And the goals are to, number 1, reduce greenhouse gas emissions. Number 2, deliver benefits to communities, but in particular, low-income and disadvantaged communities. And then 3, to mobilize financing and private capital in a way that will stimulate investment on top of that $27 billion. The first stream of funds is $7 billion for low-income, exclusively for low-income and disadvantaged communities. And the goal is to benefit those communities through zero-emission technologies. And then the second stream is $20 billion in both general assistance and low-income and disadvantaged community funding. A minimum of 40% of that money must go to low-income and disadvantaged communities. And drilling down a little bit more closely, that $27 billion fund is comprised of 3 elements. And these were announced by EPA just last month, exactly a month ago today, when we released the framework for the Greenhouse Gas Reduction Fund. The first is the National Clean Investment Fund competition at $14 billion. And that will fund 2 to 3 national nonprofits that will finance communities and community lenders and others to catalyze tens of thousands of clean technology projects. The second is the Clean Communities Investment Accelerator competition, and that will fund 2 to 7 hubs, which are nonprofits, that will rapidly build the clean financing capacity of networks of public, quasi-public, and nonprofit community lenders, things like financial institutions, credit unions, green banks, and the goal is to ensure that households, small businesses, and schools, as well as community institutions in low-income and disadvantaged communities, have access to funding for low-carbon technology. The goal is to create a pipeline, essentially, of community-led innovation. The third one is this is under the $27 billion, is the $7 billion Solar for All competition. And that will provide up to 60 grants to expand the number of low-income and disadvantaged communities that are primed for investment in residential and community solar. And that will enable millions of families in those communities to access affordable, resilient, and clean solar energy. Written comments on this framework were due on May 12th, and EPA plans to release the notice of funding opportunity for all 3 programs later this summer. Okay, now moving down to the next one on the first list I showed you, not the $27 billion, but the $5 billion fund. This is called the Community Pollution Reduction Grant Program. And the IRA created this program under a new Section 137 of the Clean Air Act. And there's 2 phases to this. The first is planning grants that EPA will award non-competitively as cooperative agreements. And then the second phase, which is the bulk of it, $4.6 billion, will be awarded through competitive grants. And though the second phase will essentially be carrying out the plans that are developed in the first phase. This gives you a little bit more of a graphic about the allocations of the planning grants, the initial money. And each state will get up to $3 million, as well as Puerto Rico. The U.S. Virgin Islands, which is also in Region 2 of EPA, will get $500,000. And then you see on the upper right, number 2, the locals. That refers to the largest population areas in the country, the largest metropolitan statistical areas. They'll each get $1 million. And we have 4 such areas in our region. And in fact, the largest in the whole country is the New York City metropolitan area, which includes 20 million people. And then the tribes and the Indian nations will each get up to $500,000. We're currently reviewing the work plans from the states, and the money will be awarded by the end of June by EPA. Remember, these are just the planning grants. We expect a separate notice of funding opportunity to come out later this year for the implementation grants. Now I'm shifting to the regulatory side. EPA has been quite busy in the regulatory side, and I'm going back to December 6, 2022, when EPA released its supplemental proposal for the oil and natural gas sector, its methane rule. Methane is a much more potent greenhouse gas than carbon dioxide, and the oil and gas sector is the largest industrial source of methane emissions in the United States. This is a graphic that shows the regulatory points in the rule, in the proposed rule. It's very much an interconnected system. The oil and gas operations go from production to distribution, and each number you see on that graphic is a point of regulation where there's emissions. And with everything we do at EPA, environmental justice is a particular concern. So for this rule, as we do with all rules, we examined the environmental justice impacts and found that Hispanic populations, Native Americans, and young children may experience disproportionate exposures and impacts from the oil and gas industry. Let's skip through this. Moving on to the motor vehicle rules for greenhouse gases. EPA announced 2 rules on April 12th. They were published different days, but one is the light and medium duty vehicle rule for greenhouse gases, and then the other is the heavy duty rule. In addition, the proposal builds on, so transportation is very critical for us to control because It's the single largest source of greenhouse gas emissions in the United States, representing about 27% of our greenhouse gas emissions. And you can see from this graphic, this is for the light-duty rule specifically. For light-duty vehicles, we measure in terms of grams per mile as opposed to fuel economy for this rule. And what we are at currently is 180 grams per mile. We have rules that go through 2026. This new rule will pick up for the model year 2027. And what will it do? It will reduce from 180 grams per mile down to 80 grams per mile, which is a very significant reduction, roughly 56% reduction industry-wide for light-duty vehicles compared with 2026, and a 44% reduction for medium-duty vehicles, all with a significant cost savings. Heavy-duty vehicles were proposed on April 27, 2023. The standards for these vehicles, they're differentiated by the type of vehicle and the use. The rule allows for averaging, banking, and trading, as does the light-duty vehicle rule. And it'll avoid approximately 1.8 billion metric tons of greenhouse gases starting in 2027 through 2055, with total cost benefits by as much as 320 billion. I'm going to shift to the power sector rule now, and this is the most recent rule. On May 11th, just last week, we issued a proposed standards for new and existing power plants. And this is also important because the power sector, as you can see in the purple in that pie chart, was the largest source of stationary source emission of greenhouse gases, and 25% of all the greenhouse gas emissions in the country. EPA projects that these proposals would cut CO2 by 617 million metric tons through 2042, with tens of thousands of reductions of other harmful pollutants that affect human health. So let's do a little bit of the regulatory history. Back in 2015 in the Obama administration, first let me just say this. We divide the world under Section 111, where these rules are promulgated, into new sources and existing sources. New sources are regulated under Section 111B, as in boy. And in 2015, we established standards for the power sector in 111B. There was a proposal during the Trump administration, but it was never finalized. So the existing 2015 rules under 111B remained. Under 111D for existing power plants, you may recall in 2015, EPA issued the Clean Power Plan to address greenhouse gases from existing electric generating units. The Trump administration repealed and replaced the Clean Power Plan with the Affordable Clean Energy Rule, or the ACE rule. That was challenged, and in 2021, just days before President Biden's inauguration, the D.C. Circuit vacated the Trump-era ACE rule, which included the repeal of the Clean Power Plan. Well, it all ended up in the Supreme Court, and last year, a little-known case, you probably never heard of it, West Virginia versus EPA, reversed the vacature of the ACE rule and upheld the Clean Power Plan repeal, so it kind of put us back. So this rule now that we are just proposing, it proposes repeal of the Trump-era ACE rule and replacement with these new standards. The proposal establishes technology standards that address the statutory standard of best system of emission reduction, and we leverage cost-effective and available technologies to do so. And in line with the Supreme Court's decision, on the Clean Power Plan, the emission limits and the guidelines that were set under 111D in this rule as a proposal follow EPA's traditional approach to regulation under Section 111. The proposal is based upon technologies that are cost-effective and can be applied directly to the power plant. It doesn't rely on generation shifting as the Clean Power Plan did. I'm going to skip over to the adaptation. So we've been really busy on adaptation as well at EPA, and it all stems from the issuance of an executive order by the president a week after his inauguration that instructed the head of each federal agency to develop a plan for adaptation that would increase resilience to the impacts of climate change. EPA issued its National Climate Adaptation Action Plan in October 2021 at the national level, and that plan directed each EPA regional office to update their 2014 plans. We had issued a plan in Region 2 in 2014, but that was basically on hold for 4 years during the Trump administration. So we were directed to update that plan. After a very robust public engagement that involved stakeholder sessions both in Spanish and in English, we released our plan on October 6th of 2022. And that plan has 4 major elements: a vulnerability assessment about the vulnerabilities throughout our region to the impacts of climate change, 44 regional priority actions, training for EPA staff, and we identified additional science needs that we have. I'll skip that. There were 6 themes in the priority actions. I'm not going to go into detail on all of them. You can see them on the slide. But the key one to focus you on is number 5 in green, using our regulatory authorities to expand our work on climate adaptation. And in doing so, we have priority actions that look to permitting opportunities, compliance monitoring opportunities, and enforcement opportunities to integrate adaptation into the work of EPA Region 2. And that's where I'll leave it. Thank you.
Thank you, Joe. Our next speaker is Liliana Villatora, who is chief of the Air Branch of EPA Region 2. She joined EPA Region 2 Office of Regional Counsel, New York, New Jersey, Caribbean Superfund Branch in 1996 and transferred to the region's Air Branch in 2007.
Thank you, Mike. It's very nice to be here today. Again, in person, feels wonderful. I am going to tell you a little bit about our enforcement program today. A couple of things. One is a settlement that we are very proud of at EPA, and the second is about an enforcement alert so that everyone's aware of what's coming. So anyway. So I'll start by telling you a little bit about the area source boiler rule, and it's got this really big name. But I think that the important part about this one rule is that it is actually about ensuring that existing oil-fired boilers are operated and maintained to achieve greater efficiency, which reduces fuel usage, and also it reduces hazardous air pollutants. We are really concerned with smaller boilers. So it is the boiler that you have in your building or larger buildings, and depending on the size of the boiler, you have to tune it up either once every 2 years or once every 5 years. Compliance with this rule was March 21st, 2014, and some folks tuned up their boilers and some folks didn't. Anyway, natural gas boilers are exempt under this rule, and we found out from the New York City Department of Education that they were actually out of compliance with this rule really early on. I'm just going to tell you a little bit about actually the New York City DOE so that you get the scope and the reason why we really felt that we needed to address this. They have over 1,800 schools, 137,500 employees approximately, and about 1.1 million students that come and go through the New York City public schools. The Division of School Facilities is actually the primary responsible party for maintenance and repair of the boiler, so it is not every school. And back in November 2021, we entered into a settlement that addressed approximately 1,300 oil-fired boilers of various sizes and ages at 566 schools. The boilers burn either number 2 fuel oil or number 4 fuel oil, which is the more polluting one. We've gotten an update from New York City DOE. They are still burning number 4 oil, but only in 1,048 boilers in the city, but 545 of those boilers do burn the number 4 oil. So a little bit about the violations and the rule. The rule is very simple. Let us know that you have one of these boilers, and then notify us that you're complying or not complying, as the case may be, and continue to do your biennial or every 5-year boiler tune-ups. And for the larger boilers, those that are 10 million BTU an hour or greater, they have to also do this one-time energy assessment. Now, the agency does not want folks to implement what they see in these energy assessments. They just want them to get a good feel for how much money they would actually save if they were to change fuel to use other means of heating the buildings. So why do these violations matter? And really it's about public health. If you look at some of the hazardous air pollutant and PM emissions, they increase cancer risk, they worsen lung and heart disease, they also lead to increased hospitalizations, premature mortality, and they do affect children and the elderly most often. And with the New York City DOE matter, it was definitely affecting the children of New York City. Fine particulate matter can also aggravate existing respiratory diseases, such as asthma, and cause heart attacks or other cardiovascular episodes. Number 4 fuel oil is still burned in 545 New York City DOE boilers, as I had mentioned. But the important part is that there is a mandate, city ordinance, that is going to ensure that these boilers are phased out by 2030. Many of these boilers, the number 4 fuel oil burning boilers, are located in minority or low-income communities that experience disproportionate impacts from poor air quality, which raises environmental justice concerns. And as Joe was telling you, we take that very seriously at EPA, and we have for many years. The settlement terms were $1 million civil penalty, and the city agreed to do a comprehensive compliance management plan for conducting periodic tune-ups and necessary maintenance repairs. And I think that the best part of the settlement is the mitigation. So we got mitigation for the excess emissions, and we look for EJ areas to get that mitigation. And it was going to cost the city, or it has cost the city up until now, about $50.5 million. And as I said, we were focusing on the larger oil-fired boilers in the city. So New York City is required to mitigate the excess emissions that would not have occurred had it completed initial tune-ups on time. And on average, these initial tune-ups were 3 years late. So we looked at their records, and we figured out that improvements from initial tune-ups would have expected to reduce number 4 oil usage by about 7.6%. And if you apply the 7.6% reduction to New York City DOE's fuel usage data for the 3-year average period of noncompliance, we calculated that New York City DOE burned in excess of 3,132,326 gallons of number 4 fuel oil, and of course with its resulting PM and HAP emissions. So environmental justice considerations for choosing the schools. We worked with the city. They gave us this list of schools, and we looked at them, we agreed with them. And this is a map that shows you where the schools are. The black dots are where the schools are located. As you can see, they are in most boroughs in the city. So we have made really great progress. 5 of the boilers in Queens, the Bronx, Brooklyn, and Manhattan have actually being converted. They were converted by October of 2022. We have hit a snag with the Brooklyn Technical High School and with PS 68 in Brooklyn. They have not been able to convert those gas boilers, those oil fire boilers into the gas boilers, but they have taken them out of service. So now there's no more number 4 oil being used. They have added temporary number 2 oil boilers, and they are going to be reducing usage, at least at Brooklyn Tech, which was the largest oil fire boiler in the city, by approximately 342,000 gallons per year. So altogether, early boiler conversions will offset New York City DOE's excess number 4 oil usage by approximately 671,000 gallons per year through the end of 2029, and we chose 2029 because they are supposed to have new boilers by 2030. But I think that we are going to finish getting mitigation by December of 2027, which is when New York City DOE will achieve the 3.1 million gallon break-even point for mitigation purposes. And so as of December of 2027, the environment will be back to where it should have been. So some estimated emission reductions here. As you can see, we have reductions in PM, PM10, 2,920 pounds per year, 1,180 pounds per year of PM2.5, 167 pounds per year of total HAPs, and we also have other incidental reductions, 13,420 pounds per year of NOx and 15,100 pounds per year of SOx. And so this has really been one of the best teams that has been put together by EPA and I think the Eastern District to really address some of the HA areas in the city of New York. And we're hoping that this sends a message that everybody should be tuning up their boiler. The other thing that I also wanted to talk about today is the scrap metal shredders. So EPA, our headquarters office, put out an enforcement alert in July of 2021. They want everyone to know about scrap shredders. So what is a scrap shredder? It's a powerful engine connected to a hammer mill. It's a rotating cylinder with large hammers that act like teeth, and they crush and shred metal into smaller pieces. It generates a significant amount of heat, and it reduces large items made primarily of metals, such as cars, refrigerators, stoves, construction materials, and other scrap, into smaller pieces of metal. Metal recycling facilities with shredders collect both ferrous and non-ferrous metals. They take the shredded material and they put it through separators. They have magnets. They make piles and sell it off. And it's recycling. It's great, but at the same time, we have to ensure that they are dealing with their emissions. There are other things that are actually put into the shredders, not only the metals. If you have a car, you just think about your car and what's in it. You have plastics, paints, caulks, sealants, rubber, switches, all sorts of things, and also fluids that are left in a refrigerator or in a car. And that process of grinding and shredding the scrap metal results in the formation of particles and the volatilization of residual fluids. So we began to see that there were serious differences in permits around the country. You had recycling facilities that seemed to be installing controls, and then others that were not installing controls at all. There were 16 emission tests performed between 2013 and 2021 at different scrap metal shredders. The maximum emission rate measured in these tests was 0.651 pounds per VOC per ton of scrap shredded, and the minimum was 0.066 pounds per ton of scrap shredded. And those are really different numbers. And the range of emission rates may be due to, the size of the shredder and to, how much actual stuff is going into the shredder. And the one thing that we know is that many of the tests did fail to collect and measure the VOC emissions that were generated by the shredders. And so we knew that we needed better tests. We have been in conversations with different scrap metal shredder companies. There are some that have several shredders around the country, and there are some smaller shops that we have also been in contact with. But we also felt that the enforcement alert was really important so that everyone in the country would know about what they needed to do next. So EPA and state investigations have identified Clean Air Act violations at these metal recycling facilities, and because they are causing excess emissions of air pollutants, in particular VOCs. We have over 250 metal recycling facilities that are currently operating with a shredder in the United States. I think there are about 16 in our region, and these facilities are often located in densely populated areas. Non-compliant shredders can have an impact on the overburdened EJ communities. And so we have been in discussions with many of these shredders so that they run tests that are appropriate. They have to enclose the shredder completely so that they can get a good test. And we are we're looking for them to continue to test and add controls. Anyway, I have a slide that folks can look at later where you can really see kind of some of the air pollution controls that have been installed around the country in some of these scrap shredding facilities. You first must capture the emissions, and you have to, when you're capturing the emissions, I see my time's up, but anyway, you can read through it, and thank you so much for listening today.
Thanks very much. We'll now hear from Jonathan Binder, who is Deputy Commissioner for Climate Change, Air Resources, and Energy at the New York DEC. He's leading New York's implementation of the Climate Leadership and Community Protection Act and DEC's regulatory and permitting activities under the Federal Clean Air Act, as well as RGGI. Before becoming Deputy Commissioner earlier this year, he served as a DEC attorney for 15 years. Jonathan.
Thank you, Mike. It's great to be here in person with everybody, and it's especially nice to be here when all of our federal colleagues, Joe, Liliana from EPA and New Jersey, we're all aligned, right? We're all aligned in terms of addressing climate change, actually taking action to reduce emissions. It hasn't always been that way, I know, maybe in some of these prior sessions. So there is a lot going on at the federal and the state level. I want to focus really on two specific things today that we're doing in this area of reducing greenhouse gas emissions and other air pollutants. I'm going to start with just giving a very, very brief overview of the Climate Act, the Climate Leadership and Community Protection Act, which is really what's charging us with doing what we're doing to reduce greenhouse gas emissions. I also want to mention the state's Community Air Monitoring Initiative, which is one of many ways that we are highlighting disadvantaged communities and trying to address the historical pollution burdens on those frontline communities. And then I want to spend a little bit of time talking about the economy-wide Cap and Invest program that we are, with our partners at NYSERDA, charged with implementing over the course of this year to really make sure that we actually achieve our Climate Act emission limit requirements. So, Climate Leadership and Community Protection Act, CLCPA, or Climate Act. Many of you are probably familiar with this law. This was passed way back in 2019 now, went into effect in 2020, and at a very high level, it sets forth our requirements on a statewide basis to reduce greenhouse gas emissions. So 85% reduction by 2050 from 1990 levels, and 40% reduction by 2030. Those are set forth in law. Those are our statutory mandates. And that is what we're doing. Everything that we're doing is in service of that objective. It also has energy generation requirements. So it requires 100% emissions-free electricity by 2040, along with 70% renewable energy by 2030. So over the last few years, the state, DEC, NYSERDA, also Public Service Commission, has been taking a variety of actions to start implementing this law. We also had the Climate Action Council go through a process of coming up with a scoping plan, which provided a whole set of recommendations for regulatory policy and other types of mechanisms to get to all of these requirements. Where are we now? I think Joe mentioned how transportation is the largest source of greenhouse gas emissions nationwide. Here in New York, it's slightly different. It's actually coming from buildings. So heating, space, and water in our buildings is what is causing the most emissions in the state, 32%. And of course, transportation is also very high. Some folks are still sometimes surprised when they see that electricity is actually number 3 on the list. But so these are all things that we have to address. This is what our task is ahead. Just another visual representation of this. You can see kind of the pieces of the pie that we have to tackle under the Climate Act. And you can see, frankly, how much work we have to do, right? So in 1990, our emissions were roughly 400 million metric tons of carbon dioxide equivalents as a state. In 2019, which is really the year that is the most recent data that we have at this point, recognizing that 2020 was a bit of a unique year with the pandemic, we had only gone down about 6%. So we still have a long way to go to get to our 2030 requirement of 246 million metric tons for New York State, and not a lot of time to do it. So before I get into the Cap and Invest program, which is going to be our primary regulatory vehicle for achieving this requirement, I did want to talk about disadvantaged communities and community air monitoring. So my colleague, Deputy Commissioner for Equity and Justice, Adriana Espinoza, will talk more about this in the next session. But the Climate Act really did create a lot of very unique and important provisions to highlight the importance of addressing disproportionate burdens in disadvantaged communities. And so that included the creation of this climate justice working group that identified disadvantaged communities. Again, Adriana will talk about this in more detail. But those disadvantaged communities that have now been established are really important for many purposes under the Climate Act, from a legal standpoint and otherwise, of course. And so one of those is requiring us, the DEC, to undertake community air monitoring in at least 4 disadvantaged communities that have potentially high exposure burdens. And we expanded that effort at the agency to look at 10 specific communities statewide. And we're doing a community input process to make sure that we're getting this hyperlocal monitoring data about air emissions, both greenhouse gases and other co-pollutants. So the purpose of this community air quality monitoring is really to identify air quality issues that are in disadvantaged communities to help inform future emission mitigation reduction strategies, both long-term strategies and short-term strategies. And one of the key components of this is that we really are partnering with and empowering community organizations to make sure that it's easier for folks to understand information on air pollution, which can sometimes be highly technical and complicated, even for those of us who have been working in this space for quite some time. So we also want to help to locate leaks in the natural gas infrastructure, along the lines of what Joe was talking about with some of EPA's regulatory actions. And again, not just greenhouse gas pollutants, but other co-pollutants as well that are really what is creating some of the most sensitive air quality issues in communities. So we have been holding quarterly community meetings with each of these 10 communities to provide updates and to provide the data that's coming out of this process. And there is additional information available on this on our website. So these are the 10 communities. 4 of them are here in New York City, 1 in each of the 4 boroughs, not counting Staten Island. And we have 6 upstate as well, or in Long Island as well. So how does this actually work? So we actually have a vendor called Aclima, which has cars, usually Priuses or Prii. I'm not really sure how to ever say that plural. But Prius cars drive around and actually go block by block in each of these study areas with sensors on the back of their cars collecting information. And they do it 20 times for each time period where, and we do it at different times of the year, different times of day, different times of seasons to try to capture some of that variability that happens with air pollution. And these are the pollutants that those cars are sensing for when they are driving around these communities. Again, not just greenhouse gases, but also other co-pollutants. And the idea is to really get a better sense of more targeted sources of pollutants that are, in our communities. We know big sources of pollutants like power plants or other industrial sources, but there's also home buildings, heatings, those kind of things also cause, of course, mobile sources causing all of these issues in local communities. So I have a California example here just because I didn't want to pick on or highlight any specific community in New York, but this is what comes out of the process, right? So we get this type of data that literally shows block by block what the pollutant is from those sensors on a gradient basis. So you can see, again, on a hyperlocal basis, what the air quality issues are in that specific community. And the purpose of all this, before I go to Cap and Invest, again, is really to identify emission reduction strategies. Again, and this is a requirement of the law. In addition to everything that I mentioned statewide for us to reduce greenhouse gas emissions, we also have to target and identify specific strategies in local communities to address the situations and the issues that we further identify through this community air monitoring process. So shifting gears a little bit to the economy-wide Cap and Invest program. So I mentioned how back of the last 3 years we had a scoping plan process that the Climate Action Council, which was made up of representatives of many state agencies as well as other representatives from elected officials, they went through a 3-year process looking at a very high level at what is the state going to do to get to our emission limits, that 40 by 30 and that 85% by 2050 emission reduction requirements. There are a whole host of strategies that on a sector by sector basis, but the one that I want to focus on is the economy-wide one. So we recognized that we needed some type of overarching mechanism to ensure that we would actually meet our emission limits. And that's the purpose of the economy-wide Cap and Invest program. So the scoping plan process recommended that the most cost-effective way to do this and to ensure that it could be done was this Cap and Invest program. And that was back in December of last year, December of 2022. I forgot what year it was for a second. The scoping plan recommended a Cap and Invest program, and then January of this year, the governor announced as part of the State of the State that she would be directing DEC and NYSERDA to actually take this recommendation and put it into action on a regulatory basis. And so we were charged, again, DEC and NYSERDA, with advancing an economy-wide Cap and Invest program that establishes a declining cap on all greenhouse gas pollutions and really does it in a way that is intended to limit costs to economically vulnerable New Yorkers and then invest the proceeds that come out of that program to further drive emission reductions and to further address disadvantaged communities in an equitable manner. So the governor set forth a bunch of principles for us as we started on this regulatory process. One of the key ones is affordability, because we want to make sure that we do this in a way that doesn't impose too much costs on particularly vulnerable New Yorkers. We also want to make sure we do it in a way that we allow for linking with other jurisdictions that have similar programs. California, Washington, other jurisdictions have economy-wide Cap and Invest programs. Of course, we in New York are participants in RGGI, the Regional Greenhouse Gas Initiative, so we do have experience in this type of program, at least for the power sector, and now we want to take that economy-wide. And so just how is this going to work? Again, we're going to be designing the details of this program over the course of this year. It's going to be setting a cap on the annual amount of emissions that is allowed in the entire state from all sources. And it's going to be declining on every year so that we actually get to those requirements at the end of the day. And so we know what the endpoints are, the 40% by 2030 and the 85% by 2050. That's what's in the law. What we don't know yet is exactly where we start, what that downward trajectory looks like. That's why it says it's an illustrative example. These are details that we need to figure out and establish pursuant to our regulatory process. So folks are probably generally familiar with the concept of Cap and Invest, but really the key thing is that large-scale emitters of greenhouse gases will be required to purchase allowances. So we, as the state, will issue emission allowances that are equivalent to 1 ton of greenhouse gas emissions. And then in order to comply with the program, those sources will have to give back to us one of those allowances to cover their emissions. And that will generate a lot of proceeds because we will be primarily auctioning those allowances. Again, a feature that we learned from the RGGI program is it is best to auction these allowances in the first instance because then we then generate those proceeds that can be used for further purposes such as further reducing emissions along with maybe giving them directly back to consumers to help address affordability. So I mentioned State of the State in January. Then we had this fun state budget process up in Albany, if any of you follow that process. So we went into this and we said, well, the Climate Act was very clear. It directs us that we have to achieve these statewide emission reduction requirements. And it says, DEC, you have to do this in regulation. So from the DEC perspective, we had all the legal statutory authority we needed to put this program into place in regulation. What we didn't have is some of the financial underpinnings that we would need, especially for a rebate or some type of mechanism that would give some portion of these proceeds back to New Yorkers to help address affordability. So that's what came out of the budget process just a couple of weeks ago. There was an enacted piece of legislation as part of that budget process that establishes these accounts. So a third of the proceeds that will be coming in later under this program will be set aside for helping address affordability, basically going directly back to New Yorkers. The other 2/3, that will be used for more traditional emission reduction measures and other kinds of recommendations that were outlined in that scoping plan. There will be an affordability study, so DEC, NYSERDA, and some of our other partners in the state will be coming out with a study at the end of this year to kind of, how does that process work? What's the best way for getting that 1/3 of funds directly back into the hands of New Yorkers to help address costs and affordability? And then all of the things that we do with the proceeds are now subject to labor and prevailing wage provisions for the projects that we invest in for the 2/3 of the funds. So how are we going to do this from a regulatory standpoint? There's going to be 3 regulations that we plan to implement over the course of this year. 2 of those are DEC regulations. We're already starting to refer to them in our parlance, which is part numbers, right? 6 NYCRR Part 253 and Part 252. One will be a greenhouse gas reporting program. We don't have that in the state right now for all types of sources, so we want to make sure we get better information from more sources about specific emissions of greenhouse gases. And then the next one will be, I think, the underpinning of the rule, the actual details of how the cap and trade, cap and invest requirements work. That's hundreds of pages of regulatory text if you look at other similar programs like RGGI or the California program. And then NYSERDA will have a rule about the auction process. How do we actually do the auction rules? So we're pretty early in the process. We're at the stage of doing pre-proposal stakeholder outreach on the development of the program. We will soon be starting more structured stakeholder sessions next month. The details of that will be, if they're not out there already, will be coming out any minute, literally, hopefully today. You will see at the beginning of June and throughout, there will be public webinars with respect to looking at the other programs like California, RGGI, what works from those programs, what are the actual regulatory details. I'm going to want to make sure that it's emphasized again that equity considerations for disadvantaged communities are really front of mind as we design this program, including with all the proceeds that we get out of this program. 35% of them, as required in the law, will have to be invested to benefit disadvantaged communities. And then these are some of the elements that we will be addressing when we go through and address the design details of the program over the next several months. Again, trying to obtain all of that input from all kinds of stakeholders before we get to the formal draft proposal stage of the process. So those are the next steps. We have been engaging with a variety of stakeholders on kind of all these different program design elements of the Cap and Invest program. I mentioned how next month we will be starting a series of pre-proposal stakeholder webinars. And that's going to be asking a series of questions. You'll be able to go to a website, see specific questions about what should the applicability threshold be, how should we treat allowances, all those kinds of details for the program, which are very important. We'll be asking questions about those, and you'll be able to get to that on climate.ny.gov. So a lot more ahead, really exciting time, but thanks very much. Thanks for being here.
Thanks very much, John. And now we'll hear from Paul Baldauf, who is Assistant Commissioner for Air Quality, Energy, and Sustainability with the New Jersey Department of Environmental Protection. Before assuming that position in 2016, he was the director of the Division of Energy Security and Sustainability for DEP, and he also oversaw the Bureau of Energy and Sustainability.
Morning, everyone. I am going to speak to what we've done on the mitigation side for climate. We have another DEP staffers here in the afternoon to talk about the resilience side, but I'm going to be speaking to everything we've done climate-wise, greenhouse gas reduction, things like that. Go through the regulatory actions we've taken, some non-regulatory actions, rules we've adopted in the last couple years, rules we're working on, and some stakeholdering that is ongoing. So these are some rules we've done the last 2 years, 2.5 years. First is Advanced Clean Trucks Program. This is a zero-emission truck sales and one-time fleet reporting requirement. This is a California rule. We are a 177 state, so we have two options: follow EPA's rules, or we can adopt California's mobile source rules. The catch with California is there's an identicality clause, so we have to do exactly what they have on their books, so that's a challenge at times to make it fit New Jersey. But everything you see here, I'm talking about mobile sources, is a California rule. Greenhouse gas monitoring reporting rule. We've been doing greenhouse gas inventories for many years, but quite honestly, we only had a few things that we knew were absolutely accurate, that we were actually having emissions reporting on. So we updated a rule to put requirements in for natural gas utilities, methane emission sources, refrigerator system owners, operators. That is online now. We're getting the data just started coming in the first of the year. So at the end of this year will be the first time that we'll be very confident that our inventory is as accurate as can be. It'll put us in a position to better be able to put resources going forward where we need to be. We don't necessarily expect that our inventory is going to change all that much, but we'll see. You know, we are making estimates based on population, based on fuel sales, things like that, that we no longer will have to do because we'll have actual numbers. So we'll see how it changes, but we're looking forward to that. Another rule we adopted, this is more commonly called our EGU rule, electric generating units. We put a CO2 emission limit on our electric generating units. It's three-tiered. So, and there's a reason for it being three-tiered. The first implementation date's 24, next one's 27, and the last one's 35. The first one in 24 is specifically looking at the dirtier units. There's no coal left in New Jersey. There hasn't been for about 2 years now. The last two plants shut down. But we do have some peakers and ones that don't run that often, but they are dirtier. So they're required by 24 either put controls on or shut down. The second tier in 27 is probably a little more interesting. We do not have our own ISO like New York. So we're part of PJM. We have no control on who's dispatched and who isn't. The way PJM works right now, it's strictly based on cost. So the cheaper bid, that's who runs. There's nothing in the space for renewables to get preference or anything like that. So we have no control over who operates in New Jersey. So that second emission limit we put on, we're very scared about leakage. Leakage has been the whole thing, even going back into Reggie. Leakage is a concern, and leakage is when a New Jersey generating facility shuts down or operates less, and a dirtier facility in Pennsylvania or somewhere else in PJM makes up that electricity. So all we've done is shut down a cleaner unit in New Jersey and a dirtier unit somewhere in the grid, so the air shed's in worse shape. And to give, on average, the emission rate in a New Jersey EGU is about half of what you see in PJM in general. So we set the limit, that second tier limit, exactly, and we can change this. The rule allows us to modify it exactly what the average PJM emission is today, meaning that if electricity is made up from somewhere else outside of New Jersey, at least that emission rate will be the same as what was shut down in New Jersey or is no longer running in New Jersey. And the last tier comes in 2035, and it basically treats every existing unit as if it was a brand new unit, state of the art, best you can do. So that's 2035, and at that point, what fossil remains in New Jersey will be treated as if they were a brand-new unit being constructed. We did in this rule also put a ban on the combustion of number 4 and number 6 heavy fuel oils. That's in effect now. There wasn't much left in New Jersey, but it's no longer allowed. And last on this one, we did have a boiler requirement in the proposal, basically electrifying boilers. We did not adopt that part of the rule for 2 reasons. One was cost, and 2 was emissions. At the end of the day, the natural gas boilers are very efficient. Electric boilers are not. If that electric boiler is getting electricity from fossil fuel-fired plant, you're actually increasing emissions by requiring people go to electric boiler. So we're rethinking that. And I think we will do something in the boiler space at some point, but that was not included in this adoption. We did a mobile cargo handling equipment at port rule. Once again, a California rule. This is not an electrification requirement, but it does require all the engines at the ports be a Tier 4 engine at some point. It's staggered in. For those of you who don't know, diesel engines never die. We have 50 to 70-year-old diesel engines at some of the southern ports that are still in operation. The northern port is much more proactive than the southern port in terms of this. They have a similar rule that really the years are a little different, but it mimics what's here. But the southern port, I mean, you literally have Tier 0 engines that's been there since 1950. So there's a time frame when you're all going to have to update to a Tier 4. This one says pending, but it was actually adopted on Monday. This is what we call our NOx omnibus rule. It's a California rule that puts requirements on heavy-duty engines and vehicle standards. The only nuance here that isn't California, we did put an inspection requirement in for medium-duty vehicles. For some reason back in the day, we only required inspections for light-duty and heavy-duty vehicles in New Jersey. Medium duties were never required. Through the years, we've found tampering in medium-duty vehicles is excessive, meaning they're either completely taking off the emission control system or they're doing some modifications. There's apparently a need to have black smoke coming out of your truck and a need to have it really, really loud. So this is going to require that they have to come to a state or private facility every 2 years, just like a light-duty vehicle going forward. So what we are doing in the second round, the acronym's PACT, Protecting Against Climate Threats. And everything I said previously was our first round. Our second round, first thing we're looking at is Advanced Clean Cars 2. Once again, a California rule. We have stakeholdered it in the last month or so. The plan is to have a proposal out in the street this summer and adopt by the end of the year. Very aggressive schedule. Adopt by the end of the year might sound like a long time. For us, it's like lightning quick. So that's our goal, and we hope to be able to do that. Also have an appliance and equipment efficiency standards law that came about in 2021. And the law is very specific. It lists all the appliances, and it has all the minimum efficiency standards you need to meet to be able to sell the product in New Jersey. It went into effect January of this year. And quite frankly, there's been a lot of confusion around what's required, what isn't required. I have all this, doesn't meet a standard, but I haven't sold it yet. It's sitting in my warehouse. What do I do? So we're stakeholdering that. We hope to have a rule out in the fall that'll really, I don't think we're going to change any of the efficiency standards in the rule, but we're going to add some clarity around the rule and exactly what the exemptions are and things like that. So it's clear to everyone exactly what you're required to do. This isn't unique. I think we're at about 7 or 8 states in the country have a similar law, and we're all kind of facing the same challenges with supply chain and things like that where we didn't envision when the law went into place. And lastly, we're doing a consumer products and architectural and industrial maintenance coatings. That's just really focusing on VOCs. We had stakeholdered this way back in 2019. It kind of got tabled with everything else. We're picking it up again. This will be out in the fall also. So some things we're doing on the regulatory side based on our proposals that went out. Clean energy compliance options for EGUs and campus facility decarbonization. They're the same but different. A lot of the comments we got was flexibility, either from the EGU operators or from, college, universities, corporate with a lot of campuses. Give us flexibility to make the decisions. Don't tell me I have to replace these boilers. Let me come back to you with a plan to reduce the same amount of greenhouse gas emissions, but give me flexibility. So we are stakeholding that. The EGU idea would be something, if I have a peaker that I can't meet that first tier emission limit, maybe I come in and put battery storage at my site, or maybe I put solar at my site, so the average emissions from the site factored in get you below what our requirements are. We're trying to see if there's an interest to do this. If there is an interest to do this, I think we'll go forward with it. It's challenging how to do it, but we want to give flexibility where it makes sense so we can get more done that maybe we could get done with just saying certain pieces of equipment have to be, upgraded or taken out of service. And that stakeholding just started in the last 6-8 weeks, so we're early on with that. So some non-regulatory efforts that we're doing. Energy Master Plan update. The first existing Energy Master Plan was 2019, so we're 5 years out. Lead by example, I'll go through the department's doing. Global Warming Response Act, 80 by 50. So our statutory requirement is an 80% reduction in greenhouse gases from the 2006 level by 2050. We also have a requirement of 50% reduction by 2030. 80% by 2050 is modeling-wise is doable. That 50% by 2030, I think it's looking more like 2034 if you believe all the modeling we've done. And our RGGI strategic funding plan I'll speak about too. So the Energy Master Plan, the governor announced beginning of the year that we were going to do a new Energy Master Plan in 24. I think we're going to stakeholder early in 23. This is kind of interesting because I talked about the 80 by 50 report. The last time we did this, Energy Master Plan came out, and then the 80 by 50 report followed. This time, I'm in a much better position because we're going to update the 80 by 50 report before the Energy Master Plan comes out so I can influence it the other way. So I'm looking forward to that part. Executive Order 315. This was fairly recent in February, and it requires our Board of Public Utilities to put programs together, provide 100% of electricity, and that should say sold, not solid, in the state to be derived from clean sources of electricity. Now, I'm only bringing this up because there's a lot of confusion here. This says the requirement is 100% electricity sold. This is not electricity generated in New Jersey. This is not electricity consumed in New Jersey. There will be fossil generated in New Jersey in 2035, and there will be fossil consumed in New Jersey in 2035. This is strictly an electricity sold requirement. Lead by example. This is something that the department's doing. I'm not sure if we're close to the largest department in terms of how many buildings we have. We have the state parks in our department, so we have a lot of property. We are going to lead by example by looking at all our department buildings, lands, doing the energy audits, evaluating greenhouse gas emissions, et cetera, and using that as a blueprint that other state agencies and county and local agencies can use in a similar way to go through their inventory. We get put on the spot a lot of times not doing what we say, for instance, right? So if we don't have all EVs in our fleet and things like that, how can we ask other agencies to do the same thing? So we're looking forward to do this to be able to give other agencies a blueprint of things to do and kind of work out the kinks and make it easier for them to follow through in the direction we'd like to see them go. So our 80 by 50 progress report, we're looking there fall or winter. If you go on our website, you can see the original report was in 2020. And it's about 120 pages, goes through every sector and gives probably 10 to 15 recommendations in each sector to the legislature what things should or could be done. This report might be, as I'm hoping, it's as small as 15, 20 pages and really focus on what good things we've done, what things we have in progress and what things that we've done nothing on since, 2020. And quite frankly, politically, that's tough to sell that last point. But the problem is, that's what we need to point out, and the big thing, we spoke about it before, is building decarbonization. We've done very little in that space. Transportation, I can point to tons of things we've done. Building decarb, a lot of work to do. So we're looking forward to that. And lastly, RGGI strategic funding plan. Our rule requires that we do a funding plan every 3 years for RGGI proceeds. We got back into RGGI in 2000, so the first report was 2000 to 22. This report is going to cover 23 through 25, focusing on three things. One, benefit communities most affected by pollution and climate change. 99.9% of the funds in the first 3 years from RGGI all went to environmental justice communities, and we're very proud of that. That's going to continue going on the next 3 years. The second piece is electrified transportation modes. First 3 years, except for sequestration, it was all about transportation. We'll continue focusing a lot on transportation dollars in the second. The third one, and this is new, electrify and decarbonize residential commercial building sector. This is huge. As anybody knows who's in RGGI, obviously New York is, the RGGI proceeds have been at an all-time high, the clearing price. There's been a lot of dollars to be able to spread, and we're looking forward to that. We've held 4 public meetings, got input. We expect to have the final plan published in June, and we look forward to continuing putting those dollars out in the street in the best way possible. And I think that's it. That's it.
We have a little bit of time for questions. And if you could push the button in front of you for the microphone.
Hello. Hi. Thank you so much for those awesome presentations, Liliana. I'm definitely going to incorporate the DOE case study into my teaching at CUNY, so thank you so much. This question is for Jonathan. So I'm so appreciative of all of the work that DEC is doing with climate justice, but we know that the disadvantaged communities map has some real problems. So there are a lot of affluent areas that are designated as disadvantaged, like Hudson Yards, the High Line, Chelsea, Williamsburg, the Hamptons. And so the first part of my question is, what safeguards is DEC going to implement so that savvy, affluent actors, including really sophisticated real estate developers, don't end up taking some of this earmarked funding, to profit themselves? And then the second part of that question is that at the same time, we know that there are very affluent communities that are misidentified as disadvantaged. There are other extremely vulnerable communities that missed the mark because of data availability, because the model's based on quantitative data. And the state just doesn't have the best data available. So, and that includes places like Southeast Queens, communities of color that are living adjacent to JFK. And so how is the map going to be revised to better include those communities? And in the interim, how is the state going to direct resources to communities like those in Springfield Gardens, Rosedale, Laurelton, Cambria Heights, South Ozone Park, that have been left out? Because we don't want this process to end up exacerbating inequality.
Yeah, so I think first point is you'll hear more about the process for how the disadvantaged communities maps were identified in the next session when Adriana speaks. So that kind of speaks to how were these communities identified in the first place as disadvantaged communities. Another point is there is built into the law a process to be reviewing these maps on an annual basis to see if there is any need to make changes to them. But in terms of the Cap and Invest program, I think it is going to be really important for us to make sure that we are designing the program with disadvantaged communities in mind. And I don't think that means we're always going to be very literal about what the boundaries of that community is necessarily. We want to make sure that all types of communities that might have burdens are being appropriately addressed under the program. And that includes how do we invest the funds, right? But also includes what do we do on the regulatory side to make sure that we're actually reducing emissions. Last point is the community air monitoring program that I mentioned. That's going to be helping us to identify, as I mentioned, additional strategies that we can implement in specific communities. So thanks for the question.
Hi, thank you. I think Natalie's point really resonates, and it's all the devil's in the details. So on Cap and Invest, I also was wondering something similar. Like, what does it look like so that, what could it look like? I realize you still haven't worked out all the details, but what could it look like to make sure that the peakers that are polluting in disadvantaged communities don't buy the allowances and just continue emitting? Like that's I think what we all think about when we worry about Cap and Invest. Just wondering if you could talk about that at all.
Sure. So I guess the first thing I want to mention is literally while we were sitting up here, we did launch a new website, right? So you can go to capandinvest.ny.gov, and some of these questions, like the one that you're asking, you can actually provide input on the specific questions. So, because we don't have all of the answers yet to any of these questions, and that's the point of the stakeholder process. But more specific to your question, there are a variety of mechanisms that we could theoretically implement to address sources that are located in disadvantaged communities. If you look back at that scoping plan that had some recommendations for how we could do this, some of the ones that were suggested for us to consider included specific limits on trading of allowances for sources located within disadvantaged communities. Another one would be sources that are in disadvantaged communities might have to provide a ratio of allowances. So instead of one allowance for one emission, maybe it's 1.5 or 2 or whatever, right? So those types of things are under consideration. But we should also keep in mind that it isn't as though the Cap and Invest program, which is really targeted at greenhouse gas emissions, is the only regulatory or permitting program that we have in place as a state. So we have a bunch of other things as well that will also help to address those types of concerns.
Thank you very much. This question is for the EPA. I'm not a lawyer, so I'm not going to ask a legal question, but an article just came out by the Brookings regarding the circular C4 by the OMB regarding regulatory change. And it says that the new regulation framework tries to use behavioral law and economics to nudge individuals to change their behaviors. And how do you incorporate that at the EPA? That's a non-legal question.
Were you referring to particular rulemaking?
It's rulemaking by the
Just the OIRA rulemaking
OMB.
that's changing the...
It's called, it's in a circular C4. It replaces OMB circular C4 that came out in 2003. It's a new regulation that's being proposed by the White House and the OMB to change regulation. It came out in April of this year. And general question is, how do you use behavioral law and economics to regulate individual decision making?
So I don't know about the particular circular you're mentioning, but one thing I can say is that the Clean Air Act in large part is viewed as a technology forcing act, and certain provisions within the statute are established in a way where we don't necessarily have to have the technologies existing at the time of promulgation of regulations. Other sections of the statute do require that. So, but there's a concept of if you create a regulation, it may force certain behavioral changes to meet the standards. And that's something that has been embedded throughout the history of certain sections of the Clean Air Act. I don't know if...
Yeah, I think this is the OMB circular on how cost-benefit analysis is done as part of the regulatory process. So it's now out for comment, and it remains to be seen what it'll look like in final form and how different agencies will implement it. Well, we are exactly at time. I want to thank our panelists for this terrific discussion. And I'm going to now ask the people from the next panel, the cross-cutting issues panel, to come up.